friends, today our topic is laws and ethics. In laws and ethics, we're going to see about essential elements of contract, offer and acceptance. Introduction. The law relating to contracts in India is contained in Indian Contract 1872. The act was passed by British India and it's based on the principles of English common law. It extends to the whole of India, except the state of Jammu and Kashmir. It determines the circumstance which promises made by the parties. Contract shall be legally binded on them. All of us enter into a number of contracts every day unknowingly or unknowingly. Each contract creates some rights and duties on contracting parties. Hence, this legalization, Indian Contract of 1872, being of a skeletal nature, deals with the enforcement of these rights and duties of the policies and the parties in India. Commencement of Act. The Act came into the effect from 1st September 1872 and applies to all contracts in India. Agreement. According to the sections, every promises making the proposal is called the promisor and the person other in an agreement. Void agreement. According to the sections, an agreement not enforcement by the law is said to be void. Essentials of valid contracts. Section 10 provides that all agreements, contracts, if they are made by the free consent of parties compartment to contract, for a law consideration and with a lawful object and are not otherwise expressively declared to be avoid. The following are the requirements of a valid contract. There shall be an offer or a proposal by one party and acceptance the proposal by the other party, which results in an agreement. There shall be an intention to create a legal regularization or an intent to legal consequence. The parties to the contract shall be compartment to the contract. There shall be a free consent between the parties to the contract. The terms of consent shall be certain. The agreement is capable of being performed. It is not impossible for being performed. Offer and acceptance. Offer. The term proposal is otherwise called as an offer. An offer is a proposal by one person, whereby an express is willingness into a consequent obligation in return for promise. Act or forbiddance to the abstain from doing anything within a view to obtaining an absent of the other such act or a subsistence. The person making a proposal is called the offerer or a proposer, and the person proposal is made by an offerer. The offer must be a valid one. The following points are not taken to be into account for a valid offer. The offer must be in a clear, definite, complete and an invalid term. It should not be a vague in terms. The communication may be in writing and or oral. The communication may be expressed in a terms or an implied terms. The offer may be general, specific, etc. If an offer is made to be specific person, it is called a specific offer. Such offer can be accepted by a specific person if an offer may be world at a large. It is a general offer. It can be accepted by any member of a public by fulfilling the condition laid down in an offer. Communication of an offer is complete completed when it comes to knowledge of a person to whom it is made. An offer which has been communicated properly continues as such until it lapses or revoked by the conceiver or offerer, or rejected or accepted by the offerer. An ideal offer should have all the essentials of a valid contract as once. It is accepted by the offer, it becomes a contract. Revocation of offer. Proposal may be revoked at any time before the communication of acceptance is completed against the proposer but not afterwards. Example, a proposes by a letter sent by a post to sell his house to B. B accepts the proposal by a letter sent by a post. A may revoke by a proposal or at any time before a moment when B posts his letter on the acceptance but not afterwards, as against the person who makes it, when it is put in a course of transmission to the person to whom it made, so as to be out of the power of the person who makes it, as against as the person to whom it was made, when it comes to his knowledge. For example, a revokes his proposal by a telegram. The revocation is completed by against A when the telegram is dispatched. It is completed against the B when B receives it. Acceptance. To constitute a promise, the intentions of parties must be communicated. One cannot accept an offer which not had been communicated to him. In general, uncommunicated offer cannot result in a promise. The term acceptance means admitting and agreeing to something to advocate to something or to. Offer can become a binding promise and results in an agreement. It must be accepted either by what the parties intended. That can be a contract should be reduced in writing. A promise should not be blind. It makes unless promise has to be asserted on it, as against the proposer when it put on a cross of transmission to him, so as to be out of the power of the acceptor, as against the acceptor when it comes to a knowledge of the proposer. A proposer by letter to sell his house at a certain price, when the proposer accepts the letter by sending a post. The communication of the acceptance is completed as against the letter is posted and against it letter is received. Acceptance may be oral or in a writing. It may be expressed or implied. If a particular method of acceptance is prescribed, the offer must be accepted in prescribed form or a manner. It must be unqualified and unabsolute and must correspond in all of the terms. A counter offer for acceptance will also amount to reject offer, but the counter of all may be accepted or rejected for the party or by the party. It must be communicated to the officer, since acceptance is completed in the moment of the communication. Mere silence on the part or the offense does not the amount of acceptance. The acceptance should be given in its a time limit is a fixed or otherwise at the responsible time and before he offered the lapse or the revoked. Revocation of acceptance. The acceptance may be revoked at the time before the communication of acceptance is completed or against the acceptor but not be upwards. The communication of the reaction is completed against the person who makes it. Is acceptance by a telegram, revocation is completed as against. When the telegram is dispatched as against or when it comes to reaches it. Void agreement. The following agreements are considered to be the void. If consideration and objects are unlaw in part, this is section 24. Agreement without consideration is section 25. Agreement in restraint of marriage is section 26. Agreement in restriction of a trade is section 27. Agreements in restraint of a legal proceeding is section 28. Agreement void for uncertainty. Agreement void for uncertainty is section 29. Agreement by a way of wagger is section 30. Consideration and objects unlaw of in part. It provides that if any part of a single consideration for one or more objects or in any part of one several consideration for a single object is unlawful, the agreement is void. Agreement without consideration. It is in writing and registered. It is expressed in writing and under the law for the time. Being forced for the registration of documents and it is made account for natural law. An affection between the parties standing in a near or a relation to each other, or unless. If is a promise to considerable for something done, it is promise to compression or compensate wholly or in a part. A person who has already voluntarily done something for a promisor or something which the promisor was legally completable to do or unless. It is a promise to pay a debt obeyed by a limitation law. It is a promise made in writing or signed by the person to charged herewith or is by agent generally or specially authorized in a behalf to pay wholly or in a part of debt which the creditor might have enforced payment but for the law for the inflations of the suits. Examples for this explanation of agreement without consideration. A promises for the consideration to be give 1,000 rupees. This is a void agreement. The natural love and affection to give his son is 1,000 rupees. A promise be into a writing or register. This is a contract. A agrees to sell the horse with 1,000 rupees for 10%. A consents to the agreement to as a freely giving. The agreement is a contract notwithstanding with the inadequacy of consideration. The inadequacy of consideration is a fact which the court taken into account of consideration whether or not a consequent was freely given. Agreement in restraint of marriage. Agreement in restraint for trade. It provides every agreement in which any one restrained from exercising a lawful possession, trade or business of any kind is not an extent weight. The exception to his exception section is a saving agreement not to carry a business on which goodwill is sold. One who sells the goodwill of a business may be aggrieved with the buyer or asserting from the carrying a similar business within the specified local limits, so as long the buyer or any person deriving little goodwill regard being had to nature of business. Agreements in restraint and legal proceeding, by which any part thereto is restricted absolutely from the enforcing its rights under or in respect of any contract by the usual legal proceeding in the ordinary tribunals, or which limits the limits in within may enforce its rights of, or which executes the rights of any party thereto or discharges any party thereto from the liability under or respect in a contract on the expiry of specified period as so restrict party from enforcing its rights and is to avoid the existent saving of contract to an attribution dispute that may rise. This section will not render illegal contract by two or more persons agreed the other dispute which may arise between them. Aspect of any subject or a class shall be referred to the arbitration, and that only the amount awarded in such attribution shall be recoverable in aspect of all dispute so referred. Saving of contract to refer questions to have already arisen. Nor shall this section render illegal any contract in writing by which two or more persons agree to refer the attribution any question between them which has already affect the provision of law and force the time being a reference to the attribution. Saving of graduation agreement of a bank or a financial institution. This section shall not be rendering illegal a contract writing by a financial institution. Stipulate a term in a guarantee or an agreement making a guarantee for extinguishment of rights or discharge of a party thereto by under the respect which a guarantee. Expiry of a specified period which not less than 1 year from the date of occurring or not occurring of a specified event for extinguishment or a discharge of such party from the said liability. Agreements void for uncertainly. It provides that agreements, that means of a which is not certain or capable of being made certain or void. Its examples: A agrees to sell to B 100 tons of oil. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. A agrees to sell to B 100 tons of oil of specified description known as an article of commerce. There is no uncertainty here to make the agreement void. A, who is a dealer in a coconut oil only, agrees to sell to B 100 tons of oil. The nature of A is trade affords to indication of the meanings of the words, and A has entered into a contract for the sale of 100 tons of coconut oil. A agrees to sell to B all the grain in any granary at Ramnagar. There is no uncertainty here to make the agreement void. A agrees to sell to B 1000 mounds of rice at a price fixed by C. As the price is capable of being made certain, there is no uncertainty to make the agreement void. A agrees to sell to B my white horse for 500 rupees or 1000 rupees. There is nothing sure which two prices was to be given. The agreement is void. exception or in favor of certain price for horse racing. This section shall not be deemed to render unlawful a subscription or contribution or agreement to subscribe or contribute made or entered into a fair or to the winner or winners of an horse race. The Indian Penal Code not affected, nothing in this section shall not be deemed to legalize any transaction connected with the horse racing in which provisions of sections of the Indian Penal Code applies. Second, consideration. The Act defines the term consideration as when the desire of the promiser, the promise or any other person has done, as abstain from doing or does, or abstain from doing, or promise to do, or to abstain from doing such something, act as the subsistence of promise is called a consideration for the promise. Consideration is essential by every contract. The following are the fundamental principles for consideration. Consideration must be at the desire of promiser. Consideration may move from the promise or any other person. In Chinnaya v. Ramaya 1882, Madras 137, it was held at a lady by deed of gift made over certain property to her daughter, directing her pay on annuity to donor's brothers as had been done by the donor herself before she gifted the property. On the same day, daughter executed in writing the favor of donors. Brother agreeing to pay the annuity, afterwards the dame declined to fulfill her promise to pay her uncle, saying that not to consideration had moved from him. The court held that the uncle could sue even through no part of the consideration received by the niece moved from him. The consideration from a mother was sufficient consideration. Types of considerations. Consideration may be the following types. Executive or future. It means it makes the form of promise to be performed in the future. Example. A makes an engagement with B to marry her in future. Executor or present. It is an act to for abhorrence made or suffered for a promise. Past. It means past act for forbearance, that is to say, an act constituting consideration took place and is complete before the promise is made. Legal rules regarding consideration. It must move the desire of the promiser. It may move from the promise or any other persons. Legality of the object. The object of the contract is ultimate purpose which the contract subserves. In contract, the object matter, the agreement, is its object. According to the section, decisions discusses about the legality of the object or consideration. The said section provides the consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that is permitted it would defeat the provision of any law, or it is fraudulently or involves or implies injury to the persons or property of another, or the court regards it is opposed to the public policy, in which of these cases the consideration of an object of the agreement is said to be unlawful. Every agreement of which the object is consideration in unlawful is void. Examples. A agrees to sell his house to B for 10,000. Here, B promises to pay the sum of 10,000 is a consideration for A promise to sell the house, and A promises to sell the house in the consideration for B promise to pay 10,000. These are lawful consideration. A promises to pay B 10,000 and 1,000 at the end for 6 months. If C, who owns the sum to B, fails to pay it, B promises to grant time to C accordingly. Here, the promise of each party to consideration for the promise of other party, and they are lawful consideration. A promises for certain sum paid to him by B to make good B at the value of his ships. If it is rent on the certain wage, here A promise is consideration of B payment and B's payment is a consideration of A promise. And these are lawful consideration. A agrees to let a daughter to be hired to B for concubinage. The agreement is void because it is immoral. Through the letting may not be punishable under the Indian Penal Code. Contracts, e-contracts. Electronic contracts are paperless contracts are in electronic form. It is changes of technology and legal requirements lead to the contract to be electronic form. E-contract is a contract model specified, executed and deployed by the software system. They are competitively very similar to a traditional commercial contracts. E-contracts also requires basic elements of a contract. The following areas ingredient of a e-contract. An offer is to be made. Offer is to be accepted. There shall be a lawful consideration. There shall be an intention to create a legal regularization. The parties must be competent to contract. There must be free and genuine consent. The object of contract must be lawful. There must be certainty and possibility of performance. The main feature of this type of contract is speed, accurate and reliable. The parties to contract have obtained digital signature from the competent authority and they have to affix the digital signature instead of manual signing. The Information Technology Act 2000 regulates such e-contracts. In this type of contract, the website of offerer adds to the world at large. Emails are used to negotiate and agree on contract terms and to sender agree to a final contract. An email contract is enforceable if an requirement of a contract is fulfilled, electronically signed and cannot be denied because by their electronic form of delivered electronically. Contracts to enforcement contractual obligations. Capacity of contract. Who are competent to contract. As per the sections, every person is a competent to contract who is of the age of majority according to the law to which he is a subject, who is a sound of mind and not is disqualified from the contracting by any law to which he is a subject. From the above provisions of this section, it means the following types of persons are not competent to contract. A person is to be attained to the age of majority minor. A person is unsound mind. A person who is disqualified from the contracting by law. Minor. As per the section of Indian Majority Act 1875, every person in India is a minor if he is not attained the age of 18 years. However, in case of minors whose person or a property or both, a guardian has to be appointed. The Guardian and Wards Act 1890, or whose property is under the subsidence of any court of wards before he attains 18 years of age is 21 years. The positions of minors' agreements, therefore, is under an agreement with the minor is void ab initio. The law of estoppel does not against a minor. It means a minor can always plead in a majority despite earlier misrepresenting to be a minor. Or in other words, he cannot be held on a liable agreement on the ground that since earlier he had asserted that he had attained majority. Doctrine of restitution does not apply against a minor. In India, the rules of restitution by a minor are similar to those found in English laws. The scope of restitution of contact by minor was examined by the PV Council in Mohiri Bibi case, when it has held that the restitution of money under the section 64th of the Indian Contract Act cannot be granted under the section 65 because of minors. Agreement is not viable, voidable, but absolutely void ab initio. Similarly, no relief can be granted under section 65 as this section is applicable where the agreement is discovered to be void or a contract becomes void. Contract beneficial to minor. A minor is entitled to enforce a contract with someone of a benefit to him. Minority is a personal privilege and a minor can be advantaged if offered and bind other parties. Minor as an agent. A minor can be appointed as an agent but is not personally liable for any his acts. Minor's liability for necessities. If somebody has supplied a minor or depends with the necessities. Minor's property is liable, but a minor cannot be held personally liable. A minor cannot should be adjusted or adjudged in what's insolvent as he is incapable of entering into a contract. Where a minor and an adult jointly enter into an agreement with another person, the minor is not liable and the contract can be enforced against the major person. Sound mind person. What is sound mind for the purpose of contracting? A person is said to be a sound mind for the purpose of making a contract if the time when just makes it. He is capable of understanding it and of forming a rational judgment as it to be effect upon his interests. A person who is unusually of unsound mind but occasionally of sound mind may make a contract when he is a sound mind. A person who usually of a sound mind but occasionally of unsound mind may not make a contract when he is of an unsound mind. Illustrations. A patient in a lunatic asylum who has intervals of sound mind may contract during those intervals. A sane man who is delirious from fever or who is drunk that he cannot understand the terms of a contract or form of a judgment as to take its effects of interest. Cannot contact willist such a delirium or a drunkenness lasts. Going by a spirit of a section, it is clear that a person of a sound mind, if he fulfills the two conditions at the time when he makes it, namely, she is capable of understanding the contract, she is capable of forming a rational judgment about the effects of such contract on his interest. A person not satisfying any of these two conditions is not treated as a person of sound mind. Others disqualified persons. The person who is disqualified from the entering into a contract is to certain for other reasons, maybe from legal status, political status, or a corporative status. Some of such categories of persons are given below. Alien enemy. An agreement with the alien enemy is a void. But agreement with the alien friend is a perfectly valid and enforceable. When the government of an alien war with the government of India, the alien is called the alien enemy, who cannot enter into a contract with any Indian citizen without the permission of government of India as same. Against the public policy contract entered with the alien before war put into a suspension during the duration of war. Foreign sovereign and ambassadors. Foreign sovereigns and the representative enjoy certain privileges and immunities in every country. They cannot enter into a contract except through the agents residing in India. They can show the Indian citizens, but an Indian citizen cannot show them. Convicts. A convict cannot enter into a contract while he undergoing imprisonment. Insolvents. An insolvent person is the one who, unable to discharge his liabilities and therefore apply for being adjust, insolvent or just proceeding, have been initiated by any or creditors. An insolvent person cannot enter into a contract relating to his property, company, or unstatutory or statutory bodies. A contract entered into the corporative body or a statutory body can be valid in only one extent by within a memorandum of associations. Free consent. Consent. Two or more persons are said to be consent when they agree to open the same thing in a same sense. It is section 13. If the parties have not agreed to the same thing or the same sense, there is no real consent and hence no contract is formed. As per sections of Indian Contract Act 1872, consent is said to be a free when it is not caused by it. Coercion, section 15. Undue influence, section 16. Fraud, section 17. Misrepresentation, section 18. Mistake subject to a provision of section 20, 21 and 22. Coercion, section 15. The term coercion have been defined in the section 15 and the act as committing or threatening to commit. Any act forbidden by the Indian Penal Code or the unlaw detaining or threatening to detain any property to prejudice of any whatever, within the intention of cause many persons to enter in an agreement. Explanation. It is immaterially whether the Indian Penal Code is or is not forced in the place where coercing is employed. From the above definition of coercion given in section 15, consent is said to be cause of a coercion when it is obtained by any one of the following: committing or threatening to commit any act forbidden by Indian Penal Code; unlawful, detaining or threatening to detain the property of another person; Coercion may come from the person party to the contract, or even third person cannot be connected with the contract directly. Unlawful detaining also amounts to coercion. If a person unlawfully detaining or gives a threat to detain any problem to prejudice of any person whatever with the intention of causing any person to enter into an agreement, amounts to coercion. Effects of coercion. According to section 19, when the consent is caused by the coercion, fraud, misrepresentation, the agreement is avoidable on the option of party whose consent was so caused. The aggrieved party may optimize to the Restraint on the contract. If the aggrieved party seeks resign the contract, he must restore the benefit according or obtained under the contract of. It should be noted that the threaten to commit suicide of all amounts to be coercion. Some special classes which are prone to be constructed cases of coercion and discussed as under. Prosecution. A merit that threat to prosecute a man or file suit against him does not constitute a coercion. In the case of Andhra Sugar v. State of APR 1968 C 599, it was held that the compulsion of a law is not a coercion. Misrepresentation, fraud, mistake, or a given even undue influence. High price and high interest rates. Charging high interest rates, high price, etc. is not a coercion, as the same is not prohibited under the Indian Penal Code. A threaten to commit suicide. Consent to any agreement at any times of obtained by threatening to commit suicide. The Madras High Court has held the threaten to commit suicide amounts to coercion in Amraju Seshmavu 1917 41 May 33. It was argued by Oldfield J., one of the judge of the bench which decided this case, that section 15 of the Indian Contracts Act must be constructed strictly and that an act which is punishable under the Indian Penal Code cannot be said to be forbidden by it. Suicide or is not punishable by the Indian Penal Code. Only the attempt to suicide is punishable. Induced influence. Section 16 of the Indian Contract Act, it defines undue influence as under. A contract is said to be induced by undue influence, where the relation subsisting between the parties as such that one of the parties in a position to dominate the will and the other uses that position to obtain an unfair advantage over the other, in particular and without prejudice to the generality for foregoing a principle. A person is seen to be a position to dominate the will of another, where he holds a real or apparent authority over the other, or where he stands in a deficiency fiduciary relation to the other, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress, where a person who is in a position to dominate the will of another enters into a contract with him, and the transaction appears on the face, or it is an evidence adduced to unconsensibly the burden of proving that such contract was not induced by undue influence shall lie upon the person in the position dominate the will of the other. Nothing in the subsection shall affect the provision for the section 111 of the Indian Evidence Act 1872 of 1872. Parent and child, guardian and ward, doctor and patient, solicitor and a client, trustee and beneficiary, religious advisor and disciple, fiance and fiancé. There is, however, no presumption of undue influence in the case of relationship of landlord and tenant, debtor and creditor, husband and wife. The wife has to be paradigmatic for such a presumption. In this relationship, undue influence has to proved. Going through the definition for such a presumption in this relationship, undue influence. Undue influence in section 16, we find the two elements are found in the undue influence. The relationship subsisting between the parties is such that one party is the position to dominating the will of another. He uses the position of obtaining an unfair advantage over the other, the person intending to avoid the contract on the ground, and undue the influence must prove the above of the two elements. Fraud. Fraud means an includes of any following acts committed by the party to a contract, or with his conveyance, or by his agents, with the intent to devise of another party threatened or its agent, or to induce him to enter into the contract. The suggestion as a fact of that which is not true by one of who does not believe it to be true. The active concealment of the fact by one having the acknowledgement of a belief of the fact. The act concealment of a fact by the having knowledge or belief of the fact. A promise made without any intention of performing it, any other fact or act fitted to deceive. Any such act or omission of the law specially declares to be fraudulent. Explanation. Mere silence as to facts likely to be affect the willingness of a person to enter into a contract is not fraud, unless the circumstance of a case are such that regard being had to them. It is the duty of the person keeping silence to speak, or unless is silence in itself equivalent to the speech. The silence amount to fraud. At times of the one party to contract make silence to some of the facts relating to the subject matter of contract. The matter on which silence is obtained or maintained by the party by the material fact. Does this amount to passive fraud under the Indian Contract Act not depend upon the various factors? Explanation to Section 17 of Indian Contract Act provides that the mere silence to facts likely to affect the willingness of the person to enter into a contract is not fraud unless the circumstance of the case are such that having a regard to them. It is the duty of a person keeping the silence speak, or unless silence itself equivalent to speech. Thus, we can say there is such exception that rule the mere silence does not amount to silence. These two exceptions are provided in the explanation to section 17 are under these standard. When there is duty to speak, where silence to equivalent the speech. However, in the following two types of the cases, silence amount to fraud are held by the court of various cases. Where there is a change in the circumstance, a representation may be true when made, but with the passage of time or changed circumstance, it may become false. Accordingly, this may be communicated to the other party, otherwise it amounts to fraud. When there is a half-truth, even when a person is not bound it to disclose a fact, he may be held guilty of fraud. If he volunteers to disclose a state of fact, partly this is so when the disclosed part renders the disclosed part false. Examples: A sells by auction to B a horse which A knows to be unsound. A says nothing to B about the horse unsoundness. This is not fraud in A. B is A's daughter and has just come to of his age. Here the relation between the parties would make A duties to tell the B to the horse is unsound. B says to A, if you do not deny it, it shall assume the horse is sound. A says nothing. Here, A's silence is equivalent to speech. A and B is traders enter upon a contract. A is as a private information of a change in prices which would affect B's willingness to proceed with the contract. A is not bound to inform B. Effect of fraud. According to section 19, when consent to agreement is caused by the coercion, fraud or a misrepresentation, the agreement of a contract voidable at the option of party whose consent was so caused. A party to a contract whose consent was caused by a fraud or misrepresentation may, if he thinks fit, insist that the contract shall be performed and that he shall be put in the position in which he would have been if the presentation had been true. However, there is a true of voidability of a contract, the option of aggravated patiently at party if such a consent was caused by misrepresentation or by silence fraudulent within the meaning of section 17. The contract nevertheless, it is not a voidable if the parties whose consent was so caused has the means of discovering the truth with the ordinary allegiance. Misrepresentation. A statement of act which one of the party makes in the course of negotiation with the review to induce the other party to enter into a contract is known as a misrepresentation. It must relate to some fact which is material to the contract. It may be expressed as a words, spoken or written, or implied from the acts and conduct the parties. The representation then wrongly made either the innocently or unintentionally into the misrepresentation when it is made innocently or intentionally. It is misrepresentation, and when made intentionally or willfully, it is a fraud. Misrepresentation had been defined in section 18 of the Act as under. Misrepresentation means and includes the possessive assertion in the manner not warranted by the information of a person, making it or that which not true. So he believes it not to be true. Any breach of a duty which without an intent to deceive against the advantage to the person committing it or anyone claiming under him by misleading another to his prejudice or to do prejudice anyone claiming under him, causing however innocently a party to an agreement to make a mistake as to substance of the thing which is subject of an agreement. From the above definition of a term misrepresentation, the following two types of a misrepresentation are noticed: unwarranted statements and breach of duty. First, we can see about unwarranted statements. When a person positively asserts, makes an absolute and explicit statement of facts, that facts is true, he has no reliable source to form his opinion, but he believed it is to be true. This one type is misrepresentation. Breach of duty. Any breach of duty which brings advantage to the person committing it by misleading to the other prejudice is a misrepresentation. Now we can see about effects of misrepresentation. As per section 19, when consent to an agreement is caused by the misrepresentation, the agreement is a contract violable or voidable at the opposition party whose consent was not caused. A party to a contract whose consent was caused by the misrepresentation may, if it thinks it, insist the contract shall be performed and that he shall be put in the position of which he had done, if the presentation had been done true. Exception. If such a consent was caused by misrepresentation or by silence, fraudulent, within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with the ordinary allegiance. Explanation. A fraud or misrepresentation which did not cause the consent to a contract of the party on whom such a fraud was practiced or to whom such misrepresentation was made does not render a contract voidable. Example. A. Intending to deceive B. Falsely represent the 100 mounts of indigo are made annually at A's factory and thereby induces B to buy the factory. The contract is voidable, the option of the B. A by the misrepresentation leads a B erroneously to believe that 500 mounts of the indigo are made annually at A's factory. B examines the accounts of the factory which showed the only 400 mounts of indigo have been made. After this B buys the factory, the contract is not voidable on account A is misrepresentation. A fraudulently informs B that A estates from the encumbrance. B thereupon buys the estate. The estate is a subject to a mortgage. B may either avoid the contract or may insist at being carried on the mortgage debt redeemed. B have discovered a vein of ore of estate A, adopts means to conceal and thus conceal the extents of a form A. Through A's ignorance, B is enabled to buy the estate at an undervalue. The contract is variable or voidable of the option of A. A is entitled to succeed to an estate of death of B. B dies. C, having received intelligence of B's death, prevents the intelligence reaching A and thus induces A to sell him to interest in the estate. The sale of voidable at the option of A. Mistake. Mistake means an enormous belief about something. It has not been defined in the Indian Contract Act. Mistake can be mistake of law or section 21, mistake of fact section 20. Mistake of law may be mistake of law of the country, mistake of law of the foreign country. Now we can see about the mistake of law of the country. When a party enters to a contract without the knowledge of law country, the contract is affected by such mistake, but it is not void. A contract is voidable because it is caused a mistake to any law of force in India. A contract is not violable because it is caused a mistake as to be law of force in India, mistake of law foreign country. Such a mistake is treated as a mistake of act and agreement such case of void. B. Mistake of fact may be bilateral mistake or unilateral mistake, and the explanations are an erroneous opinion as to value of the thing which form the object matter of the agreement is not to be deemed of a mistake or to be matter of a fact. The types of mistake of a subject matter to covers the following cases: mistake as to existence of a subject matter, mistake as to identify the subject matter, mistake as to be quality of the subject matter, mistake as to quality of the subject matter, mistake of the title of the subject matter, and at last, mistake as to price of the subject matter. Mistake as to possibility of a performance of a contract. Impossibility may be physical impossibility and legal impossibility. Now we can see the explanation of it. Mistake must be mutual. Both the parties must misunderstood each other and should be at a cross purpose. Mistake must be related to the first falling under the betrayal mistakes as under. Depends upon the nature of the promise in each case. Mistake as existence of a subject matter. If both parties are at a mutual mistake as to existence of a subject matter, if the agreement is void. Mistake as identified to the subject matter. If it usually happens when the both parties have different subject matter of a contract is in their mind, the agreement is a void due to mistake of identity subject matter. Mistake as the quality of the subject matter. If the subject matter is something essential different for the parties thought to be that the agreement is void. Mistake as to the quantity of a subject matter. Betrayal mistake of the quantity as a subject matter would render at the government agreemental avoid. Mistake as to the little of the subject matter. The agreement is void due to the betrayal mistake as to little subject of a subject matter. Mistake as to the price of the subject matter. Mutual mistake as to the price of the subject matter would render the agreement void. Mistake as to possibility of a performance contract. Impossibility may be explanations of it. An agreement is void if it is identified to be a non-feasible due to a physical factors like a time, distance, height, and etc. and legally impossibilities. An agreement is void if it is provided something shall be done which as a matter that cannot be done. Examples: A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out all the day before the day of bargain, the ship conveying the cargo had been cast away and goods lost. Neither party was aware of these facts. The agreement is void. A agrees to buy from B certain horse. It turns out to the was dead at the first time of bargain. True, neither party was aware of the fact. The agreement is void. A being entitled to the estate of a life of B agrees to sell it to C. B was dead at the time of the agreement, but both the parties was incongruent at the fact. The agreement is fact of void. Unliterated mistake as to fact. As per section 22, a contract is violable merely because of its cost by one of the parties to the as per the section. It was being under a mistake to a matter of act Unliterally mistake is allowed as a deficiency of avoiding a contract unless brought about the another party's fraud or misrepresentation.